Now, mix and match can't be done by ordinary citizens. In fact, my lord, even if I wanted to find out which companies have purchased electoral bonds, there are 23 lakh registered companies in India, 23 lakh. I would have to scan of course, every company is obliged to file the returns of their income and expenditure in the Ministry of Corporate Affairs website. And by paying some fee, I as a citizen can also access that website of that company to see what is the income and expenditure of that company. So theoretically, it is possible for me to find out which company has purchased electoral bonds worth how much, purchased and given. But I won't know who have they given it to. All that I will know is total amount purchased by them. Now, citizen can't be expected to go through. Of course, we have found out about some companies which I'll be coming to. I'll give those examples, which have purchased electoral bond because that can be seen from their disclosure to the corporate affairs. But I can't be expected to find out from 23 lakh registered companies who has purchased how much electoral bonds. But government can. State Bank of India knows. And because State Bank is owned by the government, therefore, theoretically, my lord, they can, if they exert sufficient pressure on the State Bank, they can find out who has purchased this particular electoral bond. Because State Bank has that information. Though they are prohibited by law from disclosing it to anybody by the scheme. But they have that information. And they also have the information as to which political party has encashed which electoral bond. And I am saying, my lord, that this defeats the citizens' right to know about who is funding these political parties. In fact, my lord, in a recent judgment, the Central Information Commission has ruled that these 6 national parties are public authorities under the Right to Information Act. Now, unfortunately, despite that judgment, most of these political parties are not obeying that. They are not appointing information officers, which they are obliged under the RTI Act, so that people can ask them questions. We have in fact filed a petition in this court on the basis of that CIC judgment as well as the RTI Act as well as the fundamental right of people to know, etc., which is pending, which has been separated by this court. But I am pointing out that here you have completely made mincemeat of people's right to be informed about funding of political parties by introducing an instrument which today forms the bulk of donations to political parties. They are the bulk of donations to political parties today. This instrument. Then, my lord, 12 of the scheme says, huh? Yeah, theek hai, chodo usko. The bond can be encashed only by an eligible political party by depositing the same in their designated bank account. So these are the broad salient features of the scheme. That, however, these are bearer bonds, and as I said, my lord, even the person who has purchased it may just hand it over to another XYZ, and that XYZ may give it to the political party, and therefore the political party can also turn around and say, I don't know who gave me this electoral bond. Somebody came and gave it to me. I don't know. In fact, I have been the recipient myself of, there was this register of the CBI director. Somebody came to my residence at night and gave me 2 volumes of the residence register, original register of that CBI director. And actually, I didn't know who is that person. There were these two people who came and gave it to me. But when I looked at the register, I could make out that this has to be original. Nobody can fabricate these kind of details. The time, date, car number, persons, and so on, visiting the CBI director. And on the basis of that, this court then ordered an SIT to be constituted because he was being visited by several people who were being investigated by the CBI at that point of time. But I'm saying that sometimes I get information from people whom I don't know. But I know that this is authentic information because I can make out by looking at it that this has to be authentic. In that case, my lord, initially the court asked me to disclose who gave you the register. So this was a petition by CPIL. We held a meeting of CPIL and we decided that, of course, I didn't even know, but we decided to take a principled stand that whistleblower has given it and we can't disclose the name of the whistleblower. So I'm saying that a political party can easily turn around and say, we don't know who has given it. Somebody left it. Because this is a bearer bond. Now, my lord, coming back to the submissions. So I have stated the salient features. In this, there are one or two other things also. That the window, if your lordship turns to page 12 of my written submissions, the window of sale of electoral bonds, this has to be treated as confidential by the State Bank, this information about who has purchased the bonds, and it can be disclosed only to a law enforcement agency which is pursuing some investigation. But I am saying, my lord, that if at all anybody, at one point the government had said, and this court by one interim order has also recorded, that there is at least some transparency in this because the company which purchases it has to disclose, because the political party which receives it has to disclose not the identity but has to disclose how much bonds they have to disclose, how much they have purchased, the company has to disclose, the party has to disclose how much they have received total. They say you can do some mix and match and find out who has donated. Now, mix and match can't be done by ordinary citizens for several reasons.
Ordinary citizens. Who said that you can do mix and match?
The court in one order has recorded this. This is on the basis of the submission of the government. On the basis of the government submission, the court in one interim order has recorded this. I'll show. So State Bank is the only authority which can do that mix and match. Which can do that mix and match. Citizens can't do it. Now, my lord, we have mentioned the salient features of the scheme here at the bottom of page 11, but I can show your lordship the scheme itself, which is in volume 4. Electoral bond means a bond issued in the nature of a promissory note, which shall be a bearer banking instrument and shall not carry the name of the buyer or the payee. It's like cash. Only difference is that it's a cash which can go up to 1 crore. It's a note which can go up to 1 crore, from 10,000 to 1 crore. Today, my lord, we have only notes of 500 rupees or less. Even 2,000 rupees has now been demonetized. But here, it's 10,000 to 1 crore. 1,000 to 1,000 to 1 crore. 1,000 to 1 crore. Now, eligibility for purchase of 3. Eligibility for purchase and encashment of electoral bond. The bond under the scheme may be purchased by a person who is a citizen of India or incorporated or established in India. So it can be an individual or a company. A person being an individual can buy bonds either singly or jointly with other individuals. 3. Only political parties registered under 29A of the RPA Act and have secured not less than 1% of the votes polled in the last general election to the House of People or the Legislative Assembly as the case may be, shall be eligible to receive the bond. So this itself restricts it to only those parties, not all parties are eligible, those who have received at least 1% vote, either in the Lok Sabha or in the State Assembly. The bond shall be encashed by an eligible political party only through a bank account with an authorized bank. Denomination, the bond should be issued in the denomination, shall be issued in the denomination of 1,000 to 1 crore. Validity of the bond shall be valid for 15 days from date of issue and no payment shall be made to any payee political party if the bond is deposited after the expiry of the validity period. I might just point out, my lord, on occasions they have increased the validity period under this also. And then 4. The information furnished by the buyer shall be treated as confidential by the authorized bank and shall not be disclosed to any authority for any purposes except when demanded by a competent court or upon registration of a criminal case by any law enforcement agency. So, on 7th January 2018, 5 days after the introduction of the scheme, the PIB published an article written by the then finance minister on the necessity for introducing electoral bonds. The stand of the government was that expenditures of all political parties runs into thousands of crores. However, there has not been a transparent funding mechanism of the political system. The said PIB released quotes from the then finance minister's article. Quote, the conventional system of political funding is to rely on donations. These donations, big or small, come from a range of sources from political workers, sympathizers, small business people, and even large industrialists. The conventional practice of funding political system was to take donations in cash and undertake these expenditures in cash. Sources are anonymous or pseudonymous. The quantum of money was never disclosed. The present system ensures unclean money coming from unidentifiable sources. It is wholly non-transparent system. Most political groups seem fairly satisfied with the present arrangement and would not mind the status quo to continue. The effort, therefore, is to run down any alternative system which is devised to cleanse the political funding mechanism. It further said that most donors are reluctant to disclose the details of quantums of donations given to a political party. A major step was taken by Shri Atal Bihari Vajpayee. The Income Tax Act was amended to include a provision that donations made to parties would be treated as expenditure and would thus give a tax advantage to the donor.